There we are. We are live. It's 2 p.m. and it's the day of the Scale Up to Succession Plan Summit. Next up, I have Joanne Fisher with me from the Entrepreneurs Legal Lounge. Now, I know, Joanne, you have been a lawyer for over 20 years, and many of those years were involved in mergers and acquisitions, so buying and selling businesses. And obviously, the legal aspect of buying and selling a business is extremely important, if not the most important part of buying and selling businesses, because it's obviously the role of the solicitor to help limit the losses and liabilities for the buyer or the seller, or whatever it is, whichever way round you're acting for, on which side. So obviously the legal complexities of buying and selling businesses are really important. So it was obviously important for me to bring a solicitor on today for this summit, just to talk about the legal aspects and also really the foundations that they need to have in place when they scale a business as well, not necessarily just buying businesses. And I know that's a lot of what you've been helping female entrepreneurs to do for the last few months, is getting those legal foundations in order and talking about their contracts and everything else, which is obviously a large part of mergers and acquisitions as well. So I'm going to pass over to you. I'm just going to add in your presentation and take.
Hello, everyone. Yeah, thank you very much, Emma. As you said, I am a lawyer. I'm a business lawyer. I was a solicitor and worked with one of the largest law firms in the world for over 7 years before moving to a smaller firm where I became involved in, well, I was doing property originally and then got more involved into mergers and acquisitions and buying and selling businesses when I moved to a smaller firm, and I've been doing that ever since. So that's over 13, 14 years now, purely in the business legals industry. And as you said, it's really, really, really important that we plan our exit strategy when it comes to having a business. I've been lucky enough to work with some really amazing female entrepreneurs since I've taken my business predominantly online. And I'm seeing more and more actually of people being really excited about the future and growing a business to an exit point. But as you say, and I've been listening to the wonderful speakers already today who've gone through yourself in terms of how to scale your business and get your enterprise value up, right through from how to deal with it from a mindset perspective, practicalities and operational perspectives, but obviously there's a legal element to it too. So I have got a presentation that I want to share with you all today. And what I'm going to be doing is taking you through, I've just been saying to Emma actually, because I'm so conscious when we're doing these things online, the level of detail that we could go into, it would be, I fear it could be a bit overwhelming in terms of legal jargon, and that's one of the biggest, not criticisms, but comments I receive from my clients, that they're really conscious of the legals not being a scary element. And that's one of the biggest things for me now in my business, is to make sure women feel comfortable with this process. So I hope you find the presentation with the right amount of detail. If I lose you at any point, Emma's probably already told you we are back at 7:30 tonight to ask questions. And I really hope I don't. I've tried to keep it as easy to follow as possible, just to give you the main factors that you need to be considering when selling your business and what you're going to be looking at. So if I take you through, I'm going to move this across. Can you see that okay, Emma? Is that clear? I'm not sure if you're still there. So as I've said, hello. This presentation is all focused around the legal process of how to sell your business. And the most important thing that you've got to be looking at from the very outset. So Emma mentioned earlier this morning that you want to be planning your exit strategy 1 to 3 years in advance. But what you also need to be doing when you're looking at increasing that enterprise value and making sure everything's in place is actually focusing on what kind of structure you want your business exit to take. And you have had some information. So what this means is you need to be deciding on exactly what it is you want to sell. The two most common ways of transferring business to new ownership are through via an asset sale or a share sale. But Emma also mentioned this morning, there's also an option of a management buyout, or an MBO as we call it. And I will be giving you some information on that in the end. But the two main focuses of what we'll be going through today are these two structures around asset sale or share sale. So ultimately, the choice of which method that you will be selecting will be influenced by lots of factors. So you'll be looking at legal implications, financial, and there's also the personal considerations of each of the parties that come into play when you're making a decision on how to actually sell your business off. And it will also depend largely on the kind of structure you have in the beginning. So is it a limited company, or are you a sole trader or an individual just trading for business purposes? Now, the key difference between these two is in the nature of what a potential buyer will acquire from you. So what's your buyer going to be ending up with at the end of the deal? And in a share sale, the buyer acquires the shares of the company. So if you can imagine, a limited company is owned by the shareholders. So the shares in the company are the assets that they own. And then when a person buys or acquires the shares of a company, they're buying the actual whole thing. They're buying the trade and the assets of the business. So the business continues to run on a business as usual basis, and the new owner of the company acquires all the assets, liabilities and obligations. So even those that a prospective buyer may not know about, and we'll go into that in a bit more detail soon. So you can imagine that's when your buyer is buying the whole thing from you. So you're left with nothing apart from a pot of cash, which you've obviously been looking into what you'll be doing with that money. The other way we can look to sell our business then is through the asset sale. And this is where the buyer acquires the assets which make up the business. Now, this is a really important distinction. So when a buyer acquires assets, this means there's both tangible and intangible assets that will be being purchased. So if a business owns property, land, machinery, stock, or there's the intangible assets, which are the intellectual property, so your trademarks, your copyright, all of those other things that we can't actually see, and they're also buying the goodwill from you. Now, what happens with an asset purchase is that you as the seller, you're left with the shell of the company. So if you can imagine that limited company that we transferred over in its entirety with a share sale, in an asset sale, you're left with a naked shell of a business, which is often a limited company. Not always, and in some of your cases, I know as individual owners of businesses, this would be the form of the route you would take to sell off the assets of your business. So you'd just be selling off your clients, your goodwill, your trademarks, everything you've acquired, but you haven't actually got that shell company to be selling. And the beauty of an asset sale is the liabilities remain with the company, so they don't get transferred over. Whereas you'll remember when we said we sell the shares in the company, so the whole company, that's when a buyer will acquire everything. And often the due diligence process that we'll be going through is a lot more arduous in those scenarios, because a buyer has to be 100% sure that what they're buying is completely safe and there's no liabilities or pending litigation that could crop up in the future that they'll find themselves subject to. So generally speaking, a share sale is typically more attractive from a tax perspective to a seller than to a buyer, whereas an asset sale will be more tax efficient for a buyer than a seller. So there's different ways, and all of these things will come out in the early negotiations of how do you decide to structure that deal. Also, with an asset sale, it also allows a buyer to leave behind parts of the business they consider too risky and not to take on past tax obligations. And I know we got specialist financial speakers on here that no doubt will be going into those factors with you, but it's really important to work out the tax position of a business and then decide the best way to take your sale forward. So once you've decided on the kind of structure you're looking for, and you will be given, so you'll have something in mind yourself, but obviously this is something that you'll be negotiating with your buyer right from the outset. But as I said earlier, it's something you really need to think about early on so that you can start to get all of your ducks in a row, as it were, to make sure that you're selling the right thing for your circumstances. So once you've decided on that, then you want to be looking at how you're going to be doing the deal. So negotiating the sale should be a really focused exercise with clear timeframes and targets which need to be met, or you move on. I have seen this so many times where a time frame for negotiation has not been set out very early on. So when you're negotiating with your buyer, you want to have really clear timeframes in mind so that you're not ending up wasting your time in empty negotiations that may not ever move towards a completed deal. And step one in this process is usually agreeing something we refer to as heads of terms. And these are the outlines of the parties' expectations, understandings, and key terms which have been agreed in principle at this stage. So remember, this is still a negotiation stage usually. You're not yet at a point where you're negotiating contracts, you're just negotiating a rough outline of the deal. But heads of terms are in fact signed by buyers to start, by buyers and sellers, because we want to be able to have some form of commitment from both sides before you start incurring costs of lawyers and going through a due diligence exercise or negotiating transaction documents. Because you've got to remember, these things, lawyers are expensive. We know that's the case, and the earlier they're involved, the more it will cost you to actually get your deal through to completion. So the more you can negotiate early on and have a clear set of heads of terms set out will be really beneficial for you. So the heads of terms are not intended to compel each of the parties to the deal, but they do establish the main commercial terms, as I said. And they're a summary often of the key deal terms for shareholders who are not involved in the negotiations. So sometimes you can imagine you've got a company with a number of key shareholders within the business. They won't necessarily be the people that are negotiating the deal in your business. So it will be the directors or your MD or your FD. It's not always going to be the whole of the shareholders doing the negotiations. So having a really good set of heads of terms is important because it means that you can actually pass them back to the other shareholders to give them information on the key terms that you've agreed. What usually happens is the buyer will prepare the first draft of the heads of terms. And very often we are asked as lawyers to put the heads of terms together. But of course, as I said earlier, that's when you'll start to incur costs. Very often, if you're in the business, certainly where you're buying and selling businesses all the time, you would have a general or basic pro forma set of heads of terms that you would fill in before it gets to the stage of negotiating or instructing your lawyers, because it will just keep your costs at a minimum. The heads of terms will also set out arrangements for due diligence, so i.e. what's going to happen next. And the due diligence process, then you move to due diligence, but there's different ways to doing it. So you want to make sure that your heads of terms actually are setting out exactly what you want in terms of how the due diligence process will be handled. And there's a few different options around the way that will be looked at, but usually what happens with the due diligence process, certainly if it's led by a seller, you may be looking at a data room, or if it's more often than not by the buyer, you will have something called a due diligence questionnaire, which goes into lots of information about the company itself. So have a clause in your heads of terms confirming how you will be handling the due diligence so everybody knows where they stand. Some of the provisions of the heads of terms will be legally binding. So even if the deal doesn't proceed, some of those clauses will still remain intact. And that's usually things around costs. So if a buyer pulls out, will they pay some of your costs for getting it to that stage if you've had lawyers involved in drawing up heads of terms? And also confidentiality, of course, because it's really important that all of those conversations you've had about your business, about the ins and outs of your accounts, your finances, your company structure, remains confidential even if this deal falls apart. So that's why the heads of terms are a really important stage in the process. You get your key terms set out, but you also get protection if people pull out later down the line. And some of the main terms you'll be looking at are heads of terms. In the heads of terms, are the parties. So the price that's been agreed, the description of the transaction. So is it that asset sale or is it going to be a share sale? What's the consideration? How will it be paid? Pre-completion restructuring. So are there things that need to be done within the business before this deal can even go forward? So is there some tax restructuring to do, or even organizational restructuring that a potential buyer will want? It will set out timeframes, and as I said, the DD process, but also really importantly, an exclusivity or a lockout period. Now, what this will say in your heads of terms is, and as I said earlier, you don't want this process of negotiating with your potential buyer to run on indefinitely. But they also don't want the risk that another buyer can actually pop in and say, well, actually, you're halfway through these negotiations, I'm going to offer more money. So what you would try and negotiate at this stage of the heads of terms is a lockout period to give both parties enough time to consider moving forward with the deal. So it could be that we will sign those heads of terms, and for the next 6 months you've got the next 6 months to come to an agreed completion date, or to go through your due diligence, or to come to a conclusion. But it's important to have these provisions in to stop that kind of someone else being able to come in and push your buyer out of the way, or if you're a buyer in a business, then you don't want the risk of someone else coming in. So that's an important provision. And your lawyers will advise you on all of this when you get to that stage. But as I say, if you're drawing up heads of terms yourself, these are really key terms for you to be focusing on and thinking about. Some of the main advantages then of having heads of terms, and I'll go through the advantages and the disadvantages with you, because it's not always going to be relevant to your sale. But as we said, it will establish the main terms. It will give a moral obligation to both the parties to proceed. So even though it's not a legal obligation, apart from some of these terms, if somebody's gone through that process of actually agreeing heads of terms with you and signing a document to say they're taking this deal seriously, you can be sure that they're not messing around, really. And unless something fundamental changes in terms of the deal, they will more than likely proceed. It also makes terms harder to negotiate once the deal has been agreed. So of course, once you've been through all the finer detail, you're unlikely then to have a buyer, and there will be circumstances that will happen, but you're unlikely to have a buyer that will just start moving the goalposts and changing what they want from you. You would have already thought about all of that before you get to the stage of instructing lawyers. It sets out timetables, and here, as I've said, clear instructions to lawyers. So it makes sure by the time you go to your lawyer, you know fundamentally what your deal's going to be about. You don't then have to spend weeks and weeks imparting that information to your lawyer, for your lawyer to understand it, to speak to the other side, because you've done all that work early on. So it's a really great way to start the process with your deal team. So you'll have your deal team, as Emma mentioned earlier this morning, who will be dealing with these kinds of heads of terms before it gets to the legal stage, hopefully, or you could have lawyers involved. But also include that NDA and confidentiality provisions. So there's some really great tips there on on why you should have a set of heads of terms. But actually in smaller deals and more straightforward transactions, they're not always needed. So, and they can sometimes be disproportionate on time and costs. So if you've got parties, and I've seen this happen time and time again, where a set of heads of terms have been drawn up, and then there's weeks and weeks and back and forth changing clauses and adding in words, when actually it's the main key principles that you want to be agreeing, not the finer detail in the heads of terms. Essentially, you've done all your negotiating before your due diligence. So that is a big disadvantage of heads of terms, and something that we have to be really conscious of. So always include in your heads of terms a clause that said there is room for manoeuvre if something changes, and that the buyer then is able to revise its offer if assumptions that have been made in the heads of terms stage are actually incorrect. So your heads of terms will be saying, I am paying X amount to buy X on the basis of this deal. But what if something crops up in due diligence that means the business is not worth that? You don't want then a big surprise to your seller if you come back and say, I want to change the purchase price. So actually factoring that in the heads of terms is really important, because it keeps both parties open to the possibility that things may change down the line, even though you've agreed a price in principle, remember. And I hope I'm not losing you here with all this information, but as I said, it's such an important part of selling a business that you just need to know the kind of process that you will be going through, because very often we see unrealistic expectations from clients, where they've agreed a deal with a buyer, or a buyer has gone to buy a seller's business and they want it all done by next week. And the reality is you've got to go through this process to make sure that you're being completely protected, and you've assessed and weighed up the risks of taking this business on in the future. So as I said here, the due diligence process is actually the longest and usually the most arduous part of the process, but please do stick with it, because it's your protection. It really, really is. And I mentioned earlier on that usually for this due diligence process, so just to give you a rough overview of what this is, and I will go into detail on what kind of factors people will be looking at in the due diligence process. But just as a high level kind of overview, this is where you will have your buyer crawling all over your business. This is where they're going to be checking that everything you've done in the last few years is correct, all of your tax has been paid on time, all of your documents are in order, all of your staff are happy. All of the things, all of those uncomfortable questions that we sometimes would worry about in selling a business, this is really where your lawyers do. And the lawyers of your buyers will start to really dig into the detail of your company. So all the things Emma was talking about earlier on in terms of getting your business deal ready are so important. So your contracts, your supplier agreements, your employment contracts, your director service contracts even, because not always will they be shareholders. Everything needs to be in place and watertight before you get to this stage, or this is where your deal will completely fall down, because the lawyers will pick it up straight away that there's gaps in the business, and this is then where the value of your company can be really diminished in those coming weeks when this process is going through. So legal due diligence, and as I said, sorry, just to go back, there's two ways usually of doing this. So most of the bigger deals I've worked on in the past, we'll be working from something that's called a data room. And what that is an electronic secure data storage room that the buyer and their lawyers are given limited access to for a period, the lockout period or the exclusivity period, to go in and to review all of the information on the company. So what would be uploaded into the data room would be every contract that the company has, all of the financial information, all of the tax information, all of the commercial information, anything to do with your business would be uploaded into the data room, and it would then be for the buyer's lawyers to go in, and we will go through all of those documents and review them and report back to our clients on what we believe is the case in terms of risk and potential gaps in the business that could lead to a reevaluation or a restructure of the deal itself. But you haven't always got a data room that you're working from, and certainly with smaller businesses, you would be looking at a due diligence questionnaire, which again is a document that's drawn up by lawyers. They are pro forma style, so there's some really key questions that will be in every single set of due diligence questionnaires, but we will also add in factors that are relevant to the industry, and then your seller will receive a questionnaire with probably in excess of 50 questions digging into detail on the business. And then the seller has to respond to the buyer's solicitors, confirming the answers to all of those questions. So you can understand them. By the time you've been through every single question, the buyer has a really clear understanding of your business, so they know exactly where to go and what to do next in terms of renegotiation or restructuring. So that's a really important part of the process. And it involves, so you can see I've put here, it involves an assessment of the target's legal rights and obligations, which may prompt a renegotiation of the purchase price, as well as affecting the drafting of those parts of the acquisition agreement related to the allocation of legal risk. And what I mean by that is you've got warranties and indemnities that we will talk about a little later on, that you will be given in your transaction documents, your sale agreement, and they will change depending on the outcomes of the due diligence process. And then you've got any effect that the proposed transaction may have on those rights and obligation. So will your contracts hold up? Will it secure the value that you're trying to sell your business for? So people get quite frustrated by the due diligence process. It's a very long process, and often you're going to be receiving a lot of information from your lawyers, giving you the clear picture. And very often at that stage, you're excited when you're selling or buying a business. So you don't really want to be hearing, and I totally understand that you don't want to be hearing these potential risk factors or little things that aren't exactly perfect. But that's obviously our job as lawyers, to make sure that you have all the information as possible. And that due diligence process will go through the legal things, as I've said, but it will also look at financial, commercial, and tax areas, which are really, really important to make sure you get a full rounded idea of the business and the target you're buying. So the main areas of focus in the legal due diligence process are title. So we need to make sure that if you're selling shares in a company, that the person selling the shares, so if you remember you've got a share sale, we need to make sure that the person selling those shares actually owns them, that they're not mortgaged, that they haven't been transferred to someone else, that nothing has happened to them throughout the process of their ownership that stops them being able to pass on title to those shares. And when you're looking at an asset sale, we need to make sure that the business actually has title to all of its assets. So if it owns property, we would be looking at the property documents to make sure that the business owns the property, and looking at all of the other rights that may be in the business that are being transferred out. So there's a review of the title. That's the very first starting point, i.e., can this seller sell these things or these shares to me? Do they own them? The next thing we'd be looking at then is licenses and consents. So we'd be checking to see that the licenses and consents that the business needs to operate are in place. So if you imagine if you were buying a pub or a restaurant, there will be certain licenses that place has to have to be able to operate. So we'll be going into that kind of detail and looking at making sure all of those licenses and consents are in place, and that they continue to be available as the business transfers on. So all of those permissions need to be in place for the buyer to be able to carry on the business. So again, as lawyers, we start digging around, we go online, we start looking at other factors to do with the owners of the business, and really digging deep into the operations of the business that our clients may potentially be acquiring. But please don't ever be afraid of this process, because, and I do appreciate it can feel daunting, but as Emma said earlier, if you've done the work and already made a decision 3 years ago that you want an exit strategy that focuses on mergers and acquisitions, so buying and selling, then you will be putting all of this stuff in place to make sure your business is watertight before you get to this point. So then those lawyers will be going through the due diligence process and there'll be nothing to find, because your businesses will be absolutely perfect. We'll also then be looking at finance and securities. So we're looking at the target's financing arrangements. Are there any intra-group borrowing arrangements or external lending or personal guarantees that have been given that we need to take into consideration before taking on the business? Because, and from a seller's perspective, that's really important, because if you've got a loan in your company that will transfer with the business, but you have given a personal guarantee on that loan, you need to be making sure that you've released yourself from the personal guarantee, and that your buyer will be allowed to pick up the personal guarantee for you and take that liability going forward. There will often be something called an indemnity from the point of completion, which means that the new buyer won't have liability for anything that came before, but it's really important to make sure all of those finances are really, really tied up. We're then looking at material contracts, so whether there are any unusual contract terms for key contracts within your business. So looking at your main customers, your suppliers of the business, with a particular focus, as I've put here, on price and payment mechanisms and contractual term and termination rights, because it's really important. If the value of your business is dependent on your customers and your contracts, then we need to make sure that those contracts, one, will hold up on a change of control, which is the next point that I'll come to, but also, especially in an asset transfer where you're just selling your contracts, you're not selling your whole company, we need to make sure that those contracts can be assigned. So we'll be looking specifically for a clause in your contracts that talks about assignment, because that means then that a new buyer can take over control of those contracts. It's not going to trigger a termination of that contract, which means your customer walks away and the income obviously is affected. Then the change of control. So we're looking at whether the business's key employees, customers and suppliers will remain in the business following the acquisition. And as I've just said, those change of control and assignment clauses will be really, really important, because if something happens in a business that triggers a change of control clause, which effectively means all of those contracts come to an end, the target then loses key customers and suppliers, and the value of the business plummets. So then you're renegotiating your purchase price. And that's one of the main things, actually, just to give you the heads up, that happens, because very often when we're acting for buyers in a business and you start looking over their client contracts and they're not watertight, and this is what I speak a lot about on my own page, not having those client contracts in place, or your intellectual property tied up, or your copyright being transferred to you if designers have worked on your logos, all of that can have an impact on the value of your business going forward. Then we're looking at the key employees. So we want to know that the terms of the employment of key personnel within your business are tied up, that they're not going to just walk out if you transfer your business over. And we know very often that the relationship between our key employees within the business and the directors, they're very closely linked, and there can be a bit of a ripple effect within businesses when when an acquisition or merger takes place. So we want to make sure that those contracts are watertight. Essentially, I would be saying you want to be looking at have key employment terms or key personnel tied up with termination clauses of a minimum of 3 months, but as far along the line as you can do it, because that buyer needs to know that your key personnel will come with the business and will keep the bolts moving when they take over and they're getting to know their new business. We'll also then be looking at known liabilities. So liabilities associated with the target that the buyer will acquire, any liabilities to employees, former employees. Is there any litigation pending? Is a client taking action against you? Is one of your old employees looking to take you to an employment tribunal? We'll be really asking those sensitive questions to make sure that when the business, especially in the share transfer, is taken over, that we know that there's no risks coming up. So if you imagine on the day of completion, if the next day a complaint comes in or an employment tribunal claim that wasn't known about, it can cause huge issues in the value of the business if they're having the potential effects of a claim for compensation come in. So we'll be asking all of those really detailed questions. And then we'll be thinking about conditions on completion. So whether or not there's certain conditions that have to be met for the deal to make it through to completion, and if there's any further consents that may be needed to allow the deal to proceed. So that's when we'll be saying to our clients that when we're acting for the buyers, okay, well, you could do this deal, but you may need to be looking to get a consent from X, Y, and Z to make sure their contract can be assigned over. So you can imagine the kind of detail that goes through. So that's why I say this process can be really long and drawn out, but have faith in your lawyers that when they're dragging this part of the process out, and I hear this all the time, the lawyers are holding it up, the lawyers are causing delays. We don't do it on purpose. We do it to make sure you're protected. So try not to get frustrated in these stages of the deal. It's a really, really tough part that you'll have to make some really key decisions on, but have faith in the process and know that once you've been through that and once you've done the work early on to get your business deal ready, then all of this should be quite smooth running. So what happens after we've been through that process then is that we will prepare a report to our clients. So acting for the buyers, a due diligence report then is to give the buyer sufficient information about the target, a summary of that information. So you can imagine the amount of detail that we would take on going through that due diligence process. You as our clients don't need to know the ins and outs of all of that. So what you would end up receiving from your lawyer is a high-touch report saying, these are the main terms that you need to be thinking about. These are the biggest risks for you. These are our recommendations. And that's really the most important part of the process. So have faith in your lawyer that they are doing that correctly. Go through the process with them and then have a meeting, I would always say, to run through those risks with them and decide on your next steps. What will also happen is that we'll be looking at whether specific warranties and indemnities or an adjustment in the purchase price is needed. So it's really a checklist at this stage of matters for the buyer to consider and to identify what needs to be done before completion, i.e. looking at those and things that may even actually have to be done after completion. So sometimes we as lawyers will be saying, look, this, and this is flagged up, but we don't think you need to worry about it too much. It's something to park and we will pick up after completion, but there will be fundamental things that have to be done before you get to that completion stage. So what happens next? So hopefully by this stage then, you've had your report from your lawyers, you've had a meeting to follow up on the report, and you've gone back to your seller and you've started negotiating or renegotiating the terms if you need to, or hopefully agreeing the original terms that you agreed in your heads of terms. That process can become quite fraught. A lot of deals will fall down at that stage because you will have very disgruntled or upset sellers often who don't like their business being cross-examined this way. They don't like the potential criticism that their contracts don't hold up. They didn't really realise that there is a risk of things changing, which is why it's important to have in your heads of terms that clause that says it may change down the line so that everyone's aware. So it's really important to manage the relationship at this stage, and a really good lawyer or someone that you've got a great relationship will help you through this process, because you do not want And I love my industry dearly, but unfortunately, sometimes when we have very, I don't know what the right words is here, but you can have lawyers that like the fight. In M&A deals, it's about getting a deal done. It's about bringing two people and two businesses to a table to get to meet one aim, which is often not the case with some lawyers. So make sure that the lawyer you're working with understands really that this is about doing a deal. It's not about making a deal fall apart. So if you start to see that relationship breaking down at this point, it never hurts to pull your lawyer back in and say, look, I really want this deal to happen. I appreciate what you're saying. And any good lawyer will really appreciate that feedback. I appreciate everything you're doing for me and the aggression that you're putting into this to get me the best deal. But you need to remind them sometimes that you do want this deal to proceed. It's not about you pushing it to a point of the deal falling apart. So try and keep that relationship on par and always speak to your seller. I work with a lot of clients who kind of agree terms with their seller, and then they don't speak to them again for a number of months while the lawyers are in touch. And it's actually really damaging because your seller needs to know that you're still on the same page. Because as I say, sometimes as lawyers, our job becomes quite technical at that stage, whereas you can keep it on a human level, and still be saying to your seller, look, we're looking to get this deal done. We might need you to do this, or we might need to look at this, but we're working at a holistic approach to the whole thing. So it's about you and your lawyers coming together to get the deal done. So stay in touch with your seller. Once everything is agreed then, and maybe a new price has been agreed, or there's certain warranties that we'll be looking at, have been agreed to be put into the agreement, your lawyer will then draft up the transaction documents. Now that will be different depending on whether it's an asset sale. So an asset sale, we will have an asset purchase agreement. In a share sale, we will of course have a share sale agreement. There will also be something called a disclosure letter, and potentially also there will be consultancy agreements, because very often when a seller sells their business, they will then have a period where they stay in their business post-completion and they work to help the new owner take it forward. So that kind of handover period. And in your draft document then, there will be a number, and these are the most important provisions that you will have in those documents. So warranties are promises that your seller will make to you about the business. So they would have answered all of those due diligence questions, and then you will have a list of warranties linked to the due diligence answers, which is promising. So if you're saying, our employment contracts, we've never had a claim against an employee, we've got no pending litigation, we've got no risks of an employee coming back and not being happy with their period of employment with us, your warranty will be saying, we hereby warrant that there are no potential claims from employees, which is a legal promise. And if the warranty doesn't stand up after completion, it allows the buyer to come back and make a warranty claim against you, which is a financial compensatory amount that's paid to them. And there will be certain amounts linked to the warranties. Beyond that, then you will have indemnities where you're indemnifying. So you're going one step further than just promising. You're actually saying, if you make any loss after buying this business from the promises we have given you, we indemnify you against any future loss. And that's, again, really important. It will be something that the lawyers will probably take some time to agree in terms of wording, because you will have the seller's lawyer wanting to minimize that indemnity and the buyer's lawyer obviously wanting to maximize that indemnity to make sure you're protected in the future. So those two clauses in your agreements are fundamentally the most important parts, because it's giving you the contractual protection that you need to be able to buy the business. And from a seller's perspective, you need to be really careful about the points that you're willing to warrant against. So you'll be saying to your lawyer as a seller, actually, I'm not entirely sure of this. So-and-so from 4 years ago, or this client potentially could be a claim, or we might have a problem with this supplier. If you're saying those things to your lawyers, and you must give your lawyers that information to make sure that we can give you the best advice possible and protect you, then what would happen is there would be a separate document, as I've mentioned above, called a disclosure letter, that the seller solicitor will draw up, setting out those disclosures against the warranties. So if you're saying, we hereby warrant that there's no future potential claims from an employee, you will have a separate disclosure letter that says, but we believe actually there could be a possibility, or XYZ happened 3.5 years ago. We don't think it's going to be an issue, but we're telling you about it just in case. Because if it's in the disclosure letter, then it stops your buyer in the future being able to come back to you for a breach of warranty, but it's still giving the buyer the comfort of the warranty, because you're saying, we don't really think this is going to happen, but just in case. And that will happen in your disclosure letter. Often I've seen some where we've had 15, 20 pages of every tiniest bit of detail about the company, because it protects both sides, but you're still given the warranties. So your transaction documents then will also have mechanisms for payment. So will your payment be being made to buy the business in full? Sometimes it can be a staged payment where you receive an initial payment, but then you'll receive a payment in 3 months' time, 6 months' time down the line. So that it makes it more of a financially viable option for a buyer to be able to stage the payments? Or is it deferred, subject to hitting financial targets? And what I mean by that is sometimes you will have a seller who says, I want, for argument's sake, £500,000 to buy my business. And the buyer will be saying, because of the due diligence procedure, we're not sure that your turnover is going to hit the same turnover every year for the next few years, because we think there's potentially problems with your contracts. What sometimes happens, instead of the purchase price being renegotiated, is that we would say, okay, we'll have a deferred consideration. So it's dependent on hitting certain financial targets. So you'll get a payment on the day of completion. You'll then get a deferred payment at the end of year 1, year 2, year 3, depending on the amounts that are being, sorry, I had a call come through. Depending on the amounts then that are being, sorry, Emma, I've lost my screen. I had a call come through, which is silly. Oh, sorry, guys. Okay, I'm going to carry on without my slides to finish off, because I think I may have lost them. I'm so sorry. Yes, so the mechanism for payment. So you may have a stage payment that says at the end of the year 1, 2, and 3, dependent on turnover, that you will then have deferred payments. So you may not receive all of the purchase price for the sale of your business in one chunk. And then, as I also said, the consultancy agreements, there's something to be negotiated, because you may find that actually you've sold your business for a great amount of money, but then you're actually being taken on by the new owner of your company to work with them. So you could be receiving an income monthly as well through a consultancy agreement, and that's a separate document that will need to be negotiated. Once all of those documents then have been agreed and approved, as lawyers then we will draw up something called engrossments, which are the final versions of your documents, and we will set a completion date, which will be a realistic date for everybody to go in and do a final review of the company, and contracts will be signed and exchanged, ready for completion. What often happens with some companies is that, especially with companies that hold stock, that on the day of completion, you can imagine your valuations will be fluctuating, because this process could have taken 6, 9 months to go from beginning to end. And some of the values on the stock and the assets that you have in the business may have slightly altered throughout that process. So on the day of completion or the week of completion, the parties may go back in and do another check on everything that they have, just to make sure that those figures hold up. Bear with me. I just want to check that I'm not missing anything. Okay, and I'm really sorry that my call came through then. That's quite infuriating. I thought I turned off my phone. But essentially that's the end of my presentation, and I hope you found that useful.
Oh no, that was absolutely fantastic. I mean, it obviously excites me because obviously it's what I've done for the last 8 years, and obviously worked with solicitors on both the buy side and the sell side. And you were quite right in everything that you said, in that when I review a business when I'm buying it or selling it, what I essentially compile is a risk register that that captures all the risks in not just the legal due diligence, but the financial and the operational as well. And then you, as a buyer, I would then apply a trap analysis to see what I can transfer, reduce, accept, or prevent before we go forward and complete on the deal. And that's where, as you were saying, with like the warranties and indemnities, if there's something there that we'd spotted, we might then therefore ask the solicitor to say, well, actually, can you ask the buyer to add this in as an indemnity to give us that protection that we've spotted in this due diligence? So, yeah, it is a hefty review of a business, and obviously that's why we brought Shelley in earlier, because obviously we were talking about overwhelm, and it is an overwhelming thing to go through due diligence, because like you say, you do have somebody crawling all over the business, and in kind of some ways kind of querying every decision you've ever made in your business in some way, and that can be quite a personal thing to go through. And can provide a lot of stress. So it is stressful, but it is manageable if you prepare your business early enough to be compliant, to have everything in place, to be running efficiently, and knowing your exit strategy right at the beginning. Then you can put all these things in place so that it's not a major issue when you come to exit your business. So I'm very, very pleased that complemented what I said this morning. Because it's
on the same page, and it's, it is, and unfortunately we as lawyers do sometimes need reminding of the sensitiveness of the, because we get so ingrained in the detail that we can sometimes forget. And I'd love to say lawyers are human, but sometimes we are actually trained to not be human, I believe, for a long time. Because we have to look at the detail, we have to look at the risks. And it becomes very black and white for us, but there are people behind these deals that we have to remember are there, and as you say, are feeling sensitive that their business is being criticised. So never be afraid to say to your lawyer, whoa, hold your horses, I get what you're doing and I respect what you're doing, but this is something I want to happen. I've seen too many deals that maybe don't go the right way.
Yeah, I had one last year that nearly fell through, because the seller's solicitor was literally going at it to the point where we were having an all parties call, and it was literally mudslinging between the two solicitors on their knowledge and experience, rather than focusing on actually there's a buyer and seller on the same call that actually just want to get this deal done now.
It's at dawn between the lawyers, and it's just not. It's one of the reasons I do what I do the way I do it now, because that friction is just not helpful when you've got two lawyers. And the reality is as well, I know why we do it, and we're trained to do it because of the risk to us if it goes wrong. So the first port of call when any of these deals go wrong is go back and sue the lawyers. So you can see why they do that. But essentially, we're there to facilitate a deal, not to help it fall through.
Yeah, absolutely. And you were right as well that the heads of terms are essential. I mean, some buyers tend to get a reputation because they for price chipping, because they tend to go through this process and then get a reputation for price chipping at the end. But that doesn't actually help a good reputation of you being a buyer in the industry. Yes, there are legitimate renegotiations because you found something during the deal, but in every company that I've ever worked with, it's always been important for me that we had a good reputation as buyers, so that we were seen to be fair where we could be. And especially, obviously we touched on employees, and obviously I know TUPE is obviously a massive part of buying and selling businesses as well, and that will be a whole nother hour in itself to talk about TUPE.
In my presentation, and then I thought that we will lose.
Obviously the team are important, and whenever I bought a business, we've always taken on the whole team and transferred them, and because they are essentially the crux of the value that's in that business that you're buying. It's them that have brought those sales and clients in. So I've always wanted to be seen as fair and a buyer with a good reputation with all the corporates and small businesses that I've ever worked with.
You're right, that happens a lot. And when people are so invested in that deal, and you could be weeks away from completion on, after tens of thousands of legal fees by this point on both sides being spent.
Yeah.
The tactic then to come in and renegotiate to get it over the line is actually quite dark, isn't it? Because people are too invested to say no at that stage. They need the deal done. But yeah, stand your ground. You know what your business is worth when you've done the work early on. So don't get swayed by that, and take advice if that happens.
Yeah, absolutely. At some point. Well, I've got a whole list of other questions that we're going to go through at 7:30, so I won't go through them all now, because obviously me and you could talk about this for hours with our experience. So I'll save the rest of the questions that I've got for 7:30. But thank you so much for joining us today. It's obviously really important. The legal part is obviously essential when buying and selling a business. So really appreciate you coming in and sharing the benefit of your experience and the top tips of what you need to think about. So that's really important. Thank you so much.
Thanks for having me, Emma. Okay, bye.
Thank you.